Good evening, everyone. It's Matt here from the CIOB, and I'm delighted to be here for the second time today. We have another online webinar, courtesy of Mohamed Hegazy here, who works for the Red Sea. Hello, Mohamed. I'm sure you're all ready to go. We're really pleased actually because we've had a little bit of a double run with the webinars today. At the lunchtime, we had a fantastic webinar from Andy Hewitt, one of our fellows, on cost calculations. And I was just saying to Mohamed that a lot of the questions were linking in with delay. So hopefully people have jumped from one to the next. And Mohamed's going to answer a lot of questions today on this particular topic, which is going to be really good. But before we start, I'll just do a little bit of housekeeping. First of all, it'd be really good if you could use the chat facility, as Dilip has already done here, saying good evening. I'd really like to tell us where you are tonight in the world. We always like to see where people are. I'm sure you're going to have a very hefty Saudi following, Mohamed, because that's where your base is. But let's add onto the chat where you are in the world today. Very interested to see whether we can get a nice split. I think we had over 200 registrations, Mohamed, so you might be looking at about 100 people once we get going tonight. So we've got people from Dubai, we've got people from Manny from Bahrain. Welcome. We're scoping out a face-to-face event in Bahrain pretty soon as well. Ghana, brilliant. We've got people in Qatar, fantastic. I was there just last week, actually. Dubai, fantastic. Where else? Yorkshire. There we go. Someone from back home. And I recognise Ian's name, actually, because I think he was on the session before. So welcome back, Ian. Thanks for sticking with us. Hope the weather's good. Long day. Yeah, I still can't believe you've got a meeting after this, Mohamed. You're like, must be some sort of special force robot mentality. Fantastic. We've got Motion from Abu Dhabi, and recognise Motion's name. I think I met him. And Shafir from Doha. Madina is also here. We've got people in Sri Lanka. Nottingham, AJ. Nice to see you, AJ. Oh, fantastic. We've got Mina from Kuwait as well. So that's a good range, isn't it?
Good.
Oh, it keeps coming. Fantastic. This is great. This is what you want, isn't it, Mohamed? Nice diverse audience to deal with. So now we really do encourage you posting some questions. With these sorts of topics, I don't know whether Mohamed's going to be able to answer every single question by the end of the night, but we'll do our best. If you've got a question, the best thing to do is to put it on the Q&A tab. It's just at the bottom. The reason for that is this chat moves quite quickly. So it's best to put your questions on the Q&A tab, and then we'll get around to them. The most common question is, can I have a recording of this webinar? So I'll already answer that question for everyone. Yes, of course, we're recording this webinar as we speak, and you'll be sent a copy of it tomorrow. When we talk about slides, generally we leave it to the presenters. It's normally your choice, Mohamed, whether you want to release a copy of the slides, but it is also respectfully Mohamed's IP. So it's really up to you whether you want to send a shorter version of that, but by all means, we'll be sending a recording of this webinar pretty early tomorrow for you. Okay, so so this fantastic Halloween night. I hope nobody's missing out on too much of the Halloween fun, and you're able to enjoy the rest of the evening. Sorry, finally, I'm just going to see if I've got any hub committee members that I can embarrass on the call today. Let's see. I don't see anyone just yet. But it might just be the coding of people's names on the I see Wessam's here. He came this afternoon as well. Hi, Wessam. Rohit. Kayser is here as well. So Kayser's one of our regular attendees at the CPDs. He's recently got chartered. Great to see you, Kayser. Thank you very much for all the following you're doing. I see you keeping a close contact with everyone at CIOB. And I'm just going to give Omar Abbas a shout out as well. I met him in Egypt. So at the Big Five, and I think he's Dubai now. But you've probably moved on from then even then. So great to see you. Ahmed Hamada. Fantastic. Great to see you, Ahmed. He helped us initiate the hub committee in Egypt, actually, Mohamed. So, yeah, lots going on. It's great to see a few names. I'm going to be quiet now. I've had my fun. Mohamed, delighted to have you here. Please take the floor, and guests, enjoy the webinar. Over to you, Mohamed.
Thanks, Matt. Thanks for the nice introduction. Thanks for having me. Thank you for your efforts in sharing knowledge and experience and getting professionals together from East and West, as we see today, and from Middle East as well.
I can't keep up, Mohamed. I mean, like even Omar just said he's no longer in Egypt or UAE. He's actually back in London. So, I mean, it just moves so freely, doesn't it? It's fantastic. Anyway, I'll leave it to you now.
Very good. Thank you. Today, our session will be, our webinar will be about concurrent delay, consequences of concurrent delay in construction. Here's Mohamed Hegazy. I'm civil engineer. I have a master degree in construction law from Salford University, Master of Business Administration, PMP, Project Management Professional, CCB, Certified Cost Professional. The content will be about few topics: concurrent delay identification, these many challenges in the identification itself. We'll start from how to know it's concurrent delay, contractual and legal principles behind the analysis approaches. We'll discuss different analysis approaches and the technical perspective and how it goes with these analysis approaches. And finally, some recommendations and case studies. We'll start with the definition. How can we define the concurrent delay? Is this a concurrent delay or not? What are the challenges? What are the definitions? We know from the international entities, we can see many things. We have in the definition different timing. So we'll check the timing of the events, the periods of the events, how long each event takes, the path of activities, and the different effects. This affecting the same path in the program, different path, and the effect of each one. So we have the periods of the event, we have the effect of the event, which are not always the same. So all these challenges make it not easy to define the concurrent delay and gives us different definitions. For example, we have the SCL, Site of Construction Law Protocol. The term concurrent delay is used to describe the situation where two or more delay events arise at different times. We have two definitions in the SCL, one for the concurrent delay where the events occur at the same time. They call it true concurrency, or in different times, but with the concurrent effect. So this case also can be included in the definition. So we'll start with the time of the event and time of the effect. So we can have it like concurrent effect. And we can have the causes of the delay, the same time or not the same time exactly, but the same window, we can say, or the same period of analysis, and the concurrency also in the effect. So in SCL, they call when the exactly the same time, the same effect, it's true concurrency. And if it is, as we said right now, if it is a concurrent effect, this is called by ACE functional concurrency, and the true is called by ACE literal concurrency. So these are the terminologies in ACE and SCL. The definition variables, the timing of the events. If we have, this is the contractor risk event. The contractor has lack of resources, which is causing delay to the project. This event started from that time and continued for a certain time. Another event from the employer, and third event from the employer. So we have 3 events in different timing. Are these concurrent or not concurrent? The dependency, is there any relationship? This happened because of the other one? The employer risk event caused the contractor risk event, or the contractor risk event caused the employer risk event, or they are independent in the reasons of happening. The duration of delay. Here we have lack of resources for a certain time. We have delay in design. The design is delayed and then released after this period of delay, which is shorter than the delay of lack of resources. And the other event is in a different timing with additional work will be done after the contractual completion date. So we have also challenge, a fourth challenge in the effect, the delayed path. The affected path by the concurrent delay, by the contractor risk event affected the a path of activities and caused a critical delay after the contractual completion date. The delay in design caused a delay in a different path with less quantification or less amount of days, or delays shorter. The third event is longer, the additional work. So what will be the entitlement in this case? And where is the concurrency? Is the concurrency only here between these 2 events, which are in parallel, have some intersection on the same duration? Or the concurrency will be measured from here after the completion date? All are delaying the project with different durations. We have some concurrency between these delays. So from where we will measure the concurrency? And what will be the extension of time entitlement? And it also significantly affects the compensation. If this event will have, the contractor will be entitled to extension of time claim only, for which duration, and which duration will be compensable. The contractor had the right to claim for the prolongation cost and the indirect cost and compensation. So we'll go for the definitions and the approaches and some cases, and we'll discuss the solution of this case at the end of the open hour. Cases of concurrent delay. Mainly the concurrent delay is excusable if there is an event caused delay to the contractor. So it's excusable. The contractor has the right to have extension of time. It's not all the case all the time, but most of the time is excusable. Is it compensable or non-compensable? Normally, it's non-compensable because anyway the contractor will be delayed. So the contractor will spend this and will bear this cost of the prolongation cost and the time-related cost in all cases. So no compensation in the normal cases, except the delay if the delay of the employer exceeds the contractor delay. So the employer risk event caused delay more the contractor risk event. We have a special case also, we'll see it. It is the employer risk event happened after the completion date. And we have a net method to calculate this. So we have a case of if they are equal or the contractor exceeds. In this case, it will be excusable extension of time for the delay of the employer, the delay the employer caused, but non-compensable. And this additional delay of the contractor will be responsible for it. If the contractor couldn't recover or mitigate or recover this delay, the LDs, liquidated damages, will be applied. The other case, if the employer causing a delay exceeds the delay of the contractor, the part of concurrency will be excusable, non-compensable, and the additional delay will be excusable, compensable, because it is solely here the employer delay, and it will be compensable with prolongation cost. The legal principles behind this. In delay analysis, when we analyze any delay or we have any claim overall, even if it's not only delay, if it's cost or time, we need to go to the causation. We establishing causations. We have two main things to establish causation: the legal causation, if this is caused by a breach or violation of the contract terms, and there is the risk responsibility under the contract, it is for the employer. In such case, the contractor will be entitled to extension of time. Otherwise, if it is under the contract, it is liability or obligation of the contractor will not be entitled to extension of time. And the factual causation. The factual, we need to ask why this happened. We go to the reason behind this, because of a delay in design. Why we have delay in design? Because of the contract between the employer and the designer has some issues. So it is mainly that it is employer responsibility. So we need to ask why this has happened, and if this event didn't happen, the but-for scenario, if this event didn't happen, what would be the completion date of the project? So we can know it is this delay we are measuring right now, it is caused by this event. If this didn't happen, the delay wouldn't exist. The other principle and key principle in this concurrent delay is prevention principle. The employer prevented the contractor did any event that prevented the contractor from completing the project on time or on the contractual completion date. This is the prevention principle, and it is mainly a party shall not benefit of its own wrong. So the employer risk event, it is the wrong of the employer. So the employer prevented the contractor, and consequently the employer will cannot benefit from this, cannot apply LDs on the contractor because of his own wrong. Contributory negligence, we have here two parts and two parties causing the event, so have contribution from each party. The contractual mechanisms, we will discuss also if you have any contractual mechanism for the concurrency in case of extension of time claims. The dot-on principle, and we'll check some legislations all over the world. The key one is the prevention. When and from where it comes, the prevention. The prevention is a very old principle, and it's back up to 1838. In UK, somebody prevented, or the employer prevented the contractor, if the party be prevented by refusal of other contracting party from completing the work on time or the time limited, the time stipulated under the contract, he is not liable for the default. He is not liable for the extension of time. So not liable for the delay of the project. And therefore, if we don't have a mechanism in the contract, the obligation of the contractor to complete on a certain date stipulated in the contract will not exist, and the time will be time at large. Because of this situation of the prevention, the employer prevented the contractor to avoid having time at large. It's added under the contracts a mechanism to extend the duration of the project. So we have the nature of construction projects. It takes time. It's not like when you go to a contract, buy something, so it is straightforward. You pay the money, get the product, and that's it. Here in the construction contracts, we have a duration and long time and relationship between the parties, the contractor and the employer, until the project is completed. So we agree on a time in the project. We agree we need to have this project for example, to be completed in 2 years. If the employer did any event prevented the contractor from completing the project in 2 years, the time will be at large. We will not have a different duration or a new obligation on the contractor. The contractor will be responsible to finish in reasonable time. To avoid this, it's added in the contracts a mechanism to extend the duration of the project, and we have extension of time mechanism under the contracts. In a different case, in North Midland, 2018, there was a clause in the contract or contract provision saying if it's a concurrent delay, the contractor will not be entitled to extension of time if there is any concurrency. And here the judge decided that the prevention principle is not an overriding rule. So the parties can have a freedom to agree otherwise. And this was criticized after this, because it's here it's very old principle. Under law, a man shall not get benefit of its own fault. So we have this conflict between the prevention principle and the contract provisions. If the parties can agree the concurrency, it is liability only of the contractor and no extension of time in case of concurrency or not. The analysis approaches, we have different approaches to analyze the concurrent delay. One of these approaches to check the dominant cause. If the breach of one party or the event of one party is dominating the delay and is the main reason causing the delay of the project, so this party will be fully responsible for the delay. It happened in one case, it was almost a pacing situation. The employer was delaying the contractor was delaying the project. The employer used this time of delay to do some arrangement on site and different activities. So it was like pacing. Anyway, the project will be delayed. So the other party did some pacing and did some events which may cause a delay if the parent delay didn't happen. So here in this case, one party was only responsible for the delay. The contractor was fully responsible for the delay and LDs applied. Or vice versa, the employer will be fully responsible for the delay and the contractor will get extension of time and will pay prolongation cost and will be compensable. The other approach is the first in line approach. If a party delayed the project and another event happened and didn't cause an additional delay to the current delay of the project, didn't affect the current longest part of the project in a technical way, it will not be, the other party will not have a right to claim this event. So the dominant cause was one approach for, I call it all or nothing approaches. And the first in line approach, the other approach, it is causing, if not causing, additional delay to the first event. There are other approaches, apportionment approach, Mill Mason, and other cases. The apportionment approach, it is a Scottish school in City Inn case 2007. They were building their cases mainly on the dominant cause approach. So they couldn't find the dominant cause in this case. Because of no dominant cause, they examined the contribution of the parties. And based on the contribution, if the contribution is like 20%, 80% between the parties, so they shared the rights of the delay. So it's here was built mainly on the contribution negligence and contribution among the joint wrongdoer. This also was criticized, and Brody McAdams stated they said it's a wrong approach, and English school didn't take this approach and didn't use in the further cases. And here it is the justification of why it's strong, because it didn't follow the prevention principles. Because it's contributed the and apportioned the effect, regardless if the go back to the causation, if the employer event itself prevented for a longer duration more than the decided apportionment. So there is a conflict now between the apportionment approach and the prevention principle. Malmaison approach, 1999, decided the English school. It followed this after that in 2012 and stated this is the English approach, and decided and granted the contractor full extension of time for the full period of delay caused by the relevant event. Relevant event means that it's an employer delay, employer risk event as per the GCT form of contracts. So here the court decided this is an English school different from the Scottish, because they disagreed with this apportionment approach based on the prevention principle and decided to grant the full period of delay as an extension of time. In the Malmaison, they didn't decide about the compensation. Different cases after that decided about the compensation. One of them here in the case of Walter Lilly, it checked the burden of proof. If you can prove the actual damages that occurred to the contractor because only of the employer event, and these costs and prolongation or damages wouldn't happen from the causation perspective, wouldn't happen but for the event of the employer. In such case, the contractor will be entitled to compensation for these damages. The other approach, and it is mentioned as a general rule under De Beers case law in 2010, it is as a general rule, it is applies time but no money. In case of concurrent delay, it will be extension of time but non-compensable and no compensation. It's mentioned here as a general rule, but it's not a general rule on all cases. So it is like a case by case, and different approaches are still followed and not finalized on what is the final approach, or there is an approach everybody's following. Even the contractual mechanisms and the agreement, the freedom of the contract, as we found one contract, the parties agreed if it's concurrent, will be no extension of time. It's not like this in the standard forms of contract. If you check FedEx, GCT, or NSC, will not find a clear drafting about the concurrent delay. Only in the FedEx delay, the final revision in 2017, they mentioned the concurrent delays, and the parties will agree and can agree about the approach they will follow, but they didn't directly recommend an approach. This makes a confusion because no standard form and no agreement between the parties, and the standard forms are not addressing, so you can find different applications and different consequences. The extending project duration, there is a principle about the extending time duration. When we extend the completion date of the project, it should be extended from where, if we have this case, there is an employer risk event, extended the completion excusable delay caused only by the employer, and it will extend the project from this completion date to an extension of time to a new or revised contractual completion date. So have extension of time number 1. After that, another event occurred, and it's also excusable delay. From where will be this extension of time? We'll add this duration and extend from the latest approved extension of time. So we go to the latest approved, or the latest, the last revised contractual completion date, and add the extension of time from this certain date, not from date of occurrence of the event. So we'll not take all of this duration of the event and extend from the contractual completion date or the latest. We extend only the impact from the latest contractual completion date. And this sometimes causes problems if you have 2 extension of time claims are not decided at the same time, and we have one agreed or entitlement was like 20 days, and then the other one 10 days, when we don't know these days to be added from the contractual date or would be added as a sum at 20 plus 10, 30 days from the contractual completion date. Is there concurrency between them or not? So it's very important when you submit an extension of time claim or review an extension of time claim, you decide a duration and the date, and set a new date for the project completion date. So it should be added from the latest approved extension of time. We'll go for a special case to check how can be a special case of this, as we in the content mentioned in the content, we have a special case if the employer risk event is happened after the contract completion date. This is the contract completion date, and the contractor was delayed, inexcusable delay caused by the contractor, and an employer risk event occurred at this time after the contractual completion date. And for this duration before the employer risk event, the contractor, it was only a delay of the contractor. The contractor fully responsible for the delay in this duration. And this is the effect. In this case, how we will calculate the extension of time claim, and how will we extend the project. The contractor, as per SCL, Site of Construction Law Protocol, the contractor shouldn't be exonerated from his responsibility for this delay. Accordingly, the excusable this duration will extend the project from the contractual completion date with this duration, and this will be the extension of time. If the contractor could recover the delay and complete on this date, there will be no liquidated damages. If the contractor couldn't complete in this date, the remaining duration of any delay of the contractor, the LDs will be applied. So here, this duration is inexcusable delay, and LDs will be applied if the contractor couldn't recover. And this is under SCL item protocol and item 10.14. And it's mentioned also under the American Society of Civil Engineers Schedule Delay Analysis Guidance or Standard 4.6, and it's called offsetting delay. So here they have added a terminology for this case and called it offsetting delay. Now, in conclusion, we can check the concurrency UK cases of law. We have major cases of flow, discuss the concurrency. One, as we started with the prevention principle 1838, if we don't have a mechanism under the contract to extend the project and the employer caused or there is an employer risk event or prevention, it prevents the contractor from completing on the contractual date, the time will be time at large to complete in a reasonable time. To avoid this, we should have a mechanism to extend the extension of time under the contract. The second case, it's about the dominant cause. If we have the dominant cause and we have the domination approach. Then the case of 1999, the Malmaison approach to have the full full extension of time for all the duration caused, all the extension of time caused by the employer according to the prevention principle. Then we have another case in 2000, followed the first in line approach. If the employer didn't increase the delay of the project and then cause additional delay, the contractor will not be entitled to an extension of time. And in some cases, we need to check the dependency. We can go to even the definition of the concurrent delay. Is there any dependency between the events or between the dependency between the effect itself? And in 2007, it clarified the authorities under the prevention principle. In City N, when they couldn't decide the domination, the Scottish school, they went with the apportionment approach as per the contribution of each party. And the North Midlands, 2018, the court decided prevention principle is not an overriding rule, despite many people criticize this as it is an old rule and cannot be prevailed like this. We can see also other jurisdictions in this guidance from CMS. You can have many, you will find this, they made many cases under many jurisdictions. I will mention only a few of them. US, no harm, they have an approach of no harm, no foul. And this is in match with the rule mentioned before. In these cases, it will be excusable, non-compensable. No harm, no foul for both parties. One party will get an extension of time, and the other party will not pay. The contractor will get extension of time, but the employer will not pay the compensation or prolongation cost. The employer will not impose LDs, and the contractor will get relieved from LDs and will get extension of time. Australia, almost they are following the first in line in time approach, considering the sequential delay. If the delay are not in the same interval or didn't happen at the same time, any sequence of timing. Scotland, as we mentioned, they are following the dominant cause approach, and if no domination, they go with the apportionment approach. From technical perspective, we need to examine these approaches from the technical perspective. We have two cases here. One, this is the original critical path of the project. This is the contract completion date. And we have an event by the contractor, and there is a new critical path and the project is delayed. another event by the employer, and this is the effect of the employer event. If we are following the first in time approach, this is the project is already delayed and the employer event is not causing an additional delay, so the contractor will not be entitled to an extension of time. But this can be also again against the prevention principle and the causation. This event, if the employer, if it happened only and the contractor was not delayed, it will cause and prevent the contractor from completing on the contractual completion date. So the contractor should be entitled for a delay for this period. And again, it depends on the case and how it is actually and in real life is the case, and it's always complicated, not as easy as like this. If we have the employer event happen first, and this is the new critical path, and then there is a contractor event caused and delayed the contractor delayed more than the effect of the employer risk event. What will be the extension of time entitlement? We'll go for the first in line. This happened first, so the contractor will be entitled to an extension of time up to the end of the effect of the employer risk event. And then LDs will be applied. And because of this concurrency, will be no compensation. Or if we'll go all or nothing, will be compensation for this duration. Or we need to go with the burden of proof if the contractor could prove they have additional cost because of the employer risk event, regardless of his delay. Even after his delay, the employer delay is causing additional cost. So I have different cases, different approaches, different methods of analysis, and we don't have a final decision among this. So we can have this, the duration and the apportionment. Cannot go with this technical approaches. How can you apportion this? You say that it's the contractor is entitled for the contribution. In both cases, it will be very difficult and subjective from the technical perspective. And the mail mason can be the most, or can say the best approach fitting with the technical perspective to have the full period caused by the employer to have granted an extension of time for the contractor. So this is the entitlement. In the first case, the full time caused by the employer. In the second case, the full time caused by the employer. In both cases, we have extension of time claim according to Malmason approach. In a nutshell, the summary of the approaches, we have approaches, the time but no money approach, it is excusable but not compensable. The dominant cause approach, we see the party is causing the dominant delay, or the dominantly causing the delay will get all and the other party will get nothing. First online approach and apportionment approach based on the contribution, and it's mainly if they couldn't decide the dominant cause. And the Malmason approach, which we can use with the burden of proof for the compensation. So we have different approaches, and we can check the cases and go for our situation on the project and which case is most appropriate, and it's better to go to analyze the extension of time. But I like what it is mentioned in the case of DBERS. It is like a rule, it is time but no money. So, and it is a fair solution, because in some cases we need to make set off. We need to, like contract charges, apply for a period, we can apply LDs, and then we can pay a compensation. So we don't need to apply LDs and pay compensation. And as a set off, it's time, but no money. So it's excusable, non-compensable. The contractor will get extension of time, but cannot claim or not entitled to compensation of the prolongation cost. A main thing we need always to examine while we are doing extension of time or delay analysis, the logic and common sense. And we need to check the causation. Even if we do critical path analysis and use as an evidential tool, we use the program, the time schedule, the network of it, the modeled approach. We are adding activities and fragment or subset of activities as per the employer risk event and modeling the program and running it. It can give some determination, but we need to check it has some limitations, and we need to check the common sense of it. Because we have one of the limitations is the records. If we have sufficient records, accurate records, the quality of the records can significantly affect the correctness of the analysis. The other thing is we may have a different level of details. The project is not up to a level of detail that can analyze the event. The event is in a small portion of the work. It's not affecting all of these activities and this path of activities. So we need to examine the common sense. Even we can apply this again to the critical path from the experts or professionals and practitioners, their opinion in this. And it is clear from a fact that if we have the same case and you have different delay analysts, the assessment will not always be the same. We can have different results, not only because of the approach or the data. Even if you have the same data and the same approach, the results can vary and can be different, because each analyst or each case of analysis, you have level of subjective decisions and assumptions. Can make assumptions for the duration required to do this, assumptions for the sequence, assumptions for the affected areas, assumptions for the affected path of activities. So we can make different assumptions, and it is subjective based on each analyst and based on the data he gets, the parties he consults. Normally, he cannot also make it only by himself without any consultation, without any witness from the parties, witness or the people saw the actual events and the actual circumstances. Therefore, it's subjective in nature. It's not always no exact approach, and the results not always exact, and we need to consider applying common sense tests. We need to go with the logical analysis to check if it is, we do on the critical path, we do in the program, we need to check it is logical or not. Each event itself, if we have concurrency, each event is causing this. This is logic to cause this quantification of delay or quantity delay, and these periods and the concurrency between them to have variable results. So we need to have good tools, good records, good data, good analysis, and applying common sense. Finally, to have less disputes about these cases of concurrency, it's recommended to agree on the contract, to have clarity on the contract, to agree on the contract what approach we will use. Not only the approach, the definition, how will we define the concurrent delay? How will we define the critical path, the longest path, or the critical path of the based on the total float ownership, the consequences. Normally, these things are not defined in the contract. If we have clarity and we could define it in a fair manner, because sometimes it's added to the contract, but not with a fairness, as we saw the case of the concurrency. Will be no extension of time claim, and we have a debate after this if this it's against the prevention rule, it can be overridden or not. So we need to have clarity in the contract and fairness in this situations, and if the standard forms can go in this, it will be also recommended. In case of pacing, we saw some cases it was decided based on the domination, and the other party, it was like a pacing of the work. In this pacing, it's recommended to send a notice of official pacing to the other party to be clear it is pacing, not concurrency. And there is a pretty good recommendation from SCL. It's not followed until now, to have LDs for the employer delays, like we have LDs for the contractor delays. So we have contractor delays, the employer has the right to apply LDs on the contractor. If we have it vice versa, it will be highly recommended also to measure the prolongation cost, because if we say it's compensable delay, in this case it's also challenging to measure the actual damages and the quantum of compensation. Due diligence by the contractor to mitigate the delay and not exaggerating on the effect of any delay. Partial taking over, if it's helpful for both parties to have partial taking over, and in case of applying LDs, we will minimize the LDs and the damages. Caring about the soundness of the program revisions. We have sound programs and well prepared, reviewed, verified, and consent on the programs, and we agree which program we will use, as well as we agree which approach we will use in the extension of time and delay analysis. The entitlement can be reviewed and adjusted with time, and this is applied only respectively under the GCT standard form, but the other standard forms are not going with this much of the flexibility to adjust the extension of time. If we have an extension of time and we are analyzing it right now, then the actual site and actual circumstances was different, and everybody got that it is not the fair determination. The contractor should be entitled to an additional extension of time. We can extend this because normally we grant a minimum extension of time at the time of the event, and we are not aware of all circumstances and the full effect. Now I finished my recommendation and my presentation. We go for a few cases and we go for the questions. Case number 1. It's about the dot-on principle. We have critical delay in material submission. The contractor delayed to submit the material of a long lead item, and then the employer or the consultant delayed in approving it. The engineer delayed in approving. We have, this is the path before the events, unimpacted path with the total float. Then the delay of the contractor became a critical delay, and this is the impact after the delay of the contractor. The delay in approval made a cumulative impact on the same path with this duration. What will be the extension of time entitlement? Up to 1, up to 2, or what will be the extension of time entitlement? Can we see in the chat? Is this a concurrent delay or not a concurrent delay, by the way? Yes or no? Is it a concurrent or not concurrent delay? not concurrent, yes, concurrent, 2, 2 minus 1, 1, and concurrent, yes, concurrent. From the definition, the concurrent delay should be independent. So here there is dependency that this event would not happen. It happened after the delay in submission. There is a delay in approval. So there is dependency between the events. It can be dependency in the effects. Also, we need to check here the dependency. It's dependency on the event. This didn't occur because of the other event. It's not causing each other, but they are on the same path. So we'll have also here challenges in defining, is it concurrent or no concurrent? And in the extension of time claim, we can go with the net approach, 2 minus 1, and this will be only the extension of time entitlement. So we can go with the net or dot on principle. So have extension of time 2 minus 1 and added from the contractual completion date, because the employer delay caused only this difference and didn't contribute or participate for the delay from the completion date to date 1. Here the compensation needs to be, normally it needs to be retrospectively decided and determined. If there is actual damages for the contractor because of this extension of time, it wouldn't happen only if the contractor is delayed by his event. And is the contractor delayed retrospectively, then after the completion of the project, delayed more than the entitlement, and there is an application of LDs, so we'll have the compensation will be complicated in a different scenarios. Case 2, the dependency of events and the impact. We have independent employer risk event on a capable delayed path by the contractor. In the same path, there is a delay of the contractor due to lack of resources, and another delay of the employer because of the design change. So here it's not the same submission, but same submission or same material submission and approval, and the relationship, there is a relationship between them like the previous case. No, here it's a different events, but affecting the same path. And we did here a scenario which checked the effect only of the design. If the delay of contractor is mitigated or programmed before the delay of the contractor, and we checked the effect of the design change. And we got now 3 dates, 1, 2, and 3. What would be the extension of time? What do you see the entitlement of extension of time of this case? Up to date 1, date 2, or date 3? 2 minus 1, 3 minus 1. And you like the net approach, you like the dot on principle, and you want to apply it. Up to 2 only. Two. Three minus 2. We have here the contractor delay, and this is it increased because of the employer. So if we are using the first in line approach, we'll go with 3 minus 1. This is the additional delay caused by the employer. If you want to have the independent impact, if the go for the causation and if only the employer risk event occurred, what would be the impact? So the impact only if the employer risk event to check the entitlement to the extension of time will go to 2. Can go to the extension of time up to 2. If the cumulative, there is a mitigation by the employer, as we said, there is a duty of mitigation by the employer and should be done with due diligence, that the mitigation of the employer is less than the independent impact, will go with the mitigated path. So in this case, we can go extension of time up to 2. And if the contractor could complete on 2, the date of 2, without applying LDs, now without being subjected to LDs behind the date 2, we will have the right of compensation for 2 minus 1 if we could complete on time. If the contractor delayed, so that's why the compensation, we need to make it retrospectively. So we cannot decide the compensation now at the time of the event. We need to wait until the completion of the project and decide the compensation. You can check like approximate entitlement, would be entitled in this case or not, and then we'll check the actual damages after completion of the project. Here the case, the final one, the last one, the case we started the webinar with is the case of the contractor risk event on a different, and the employer risk event on a different path, and a second employer risk event on a third path of the project. And in this case, what do you see the entitlement of extension of time? We have different approaches, so it's okay to have different opinions, and it depends on the case. If you have this actual case and the examining and the analyzing this actual case, you will have more records, more complications, and you can decide based on the actual circumstances. So here we have extension of time up to 3. Fraz up to 3. Anybody else? Osama also 3. 3 minus 2. Mohamed Abdul Jabbar 3 minus 2. Dilip 3 minus 2. Arham 3. So we have some people is going with 3 and 3 minus 2. If we'll go with time but no money, so the employer is causing delay up to 3. So up to 3, it's time. The concurrency of the contractor delays only up to 2. So up to 2 is time but no money, and from 2 to 3, it will be compensable. If we follow this approach, as I recommend, it is the technically the technical right approach. Okay, so we have extension of time full, as Mason say, full duration up to 3, and the compensation will be from 3 to 2, or depends on burden of proof, the actual damages occurred or happened to the contractor because of the employer a risk event wouldn't happen only of the contractor delay, in case of the contractor delay. Thank you. I finished now. If we have any questions, we'll go with the question, Matt. What do you say? I think we have like.
Thank you, Mohamed.
Thank you.
I can honestly say that I think you've had the best crowd participation from any discussion. It's really good to see people getting engaged with the questions you're posing. And thank you very much for everyone for joining in on those as well. It's really good. So there are some questions. I don't know whether can you see them where you are right now?
Yes,
or?
I see like
So it's not too many, because I did say to you, I did warn you before that there's going to be loads, but
good. I check with the questions. Not, I think some people added in the chat something, but I cannot check the chat. I'll go with the questions. I have 5 questions. In some of the contracts, question 1, in some of the contracts, the contractors has, with or without consent, has agreed or to waive its right to extension of time during concurrency. Concurrent delay become non-compensable. It can become non-excusable even if they agreed in the contract like this. And we saw the case, and we saw how is it criticized. If there any ways contractor can overcome this situation with the light of governing law or any other means during concurrency. As we saw, it's mainly on the agreement of the contract between the parties in the contract. So the contract is prevailing everything. So if they agree on the contract, they should apply what they agreed on the contract. Unless if we can go with this, again, it's a prevention principle and can be accepted. It cannot be agreed otherwise. The second question, what challenges or limitation might be associated with the but-for test when assessing concurrent delay? It's many challenges to prove this. Yeah, to prove this on the program itself. How can you remove the delays of one party and add the delays of the other party? Are you going to apply this on the baseline, or you can mitigate the delays on an updated program with actual data, mitigate the delays, and then add the delays again of the both parties and check the scenarios? So the challenge is you need to make different scenarios. You cannot use only one program to do this. You need to make different scenarios to check the concurrency. You can apply both events on 2 baselines, and then apply on the updates and check if there is a mitigation measures are taken, and then you can go with the proper or the most appropriate determination among these scenarios. The other thing, you need to check the causation with the experts and witness and professionals to check the causation and to apply the right causation of each event, how long it takes, what is the affected area, and what are the consequences. Third question, how does the first in line approach consider sequencing and the order of events? So I prefer if you can check, I'll share the presentation, check the cases which discuss the first in line, and you can see how they are addressing this, because it is challenging if it is causing additional delay to the longest path or not. So if it's they consider the new critical path, it's the project is already delayed, and if the employer risk event is causing additional delay or not. So this is the basis, and it's not always correct. I say we have one move in Egypt. There is 2 twins. They are living with one identity, one ID. They went to the bank at the same time, and they throw the money twice at the same time. So it happens in time. We can use the same time to do different activities, but it cannot happen in the money except in this case. So dealing with the money with the same approaches you are dealing with the timing, it's not always correct. So first in line, it's already delayed, so the other party can do anything, and it's not his liability if he has an event concurrent with this. It's not always correct from the technical perspective. It's not like the money. They cannot use the money, or with the same people cannot use the same money. No, the same people can use the same time. So it is a bit different, and the same in the apportionment approach. I have the same, can say, the same problem with the apportionment and first in line approach, but it's applied in different cases. We cannot say it is wrong. In a special case, another question from Hashmi, in a special case, the employer risk event may be a result of a consequences of contractor delay event. So this is not a concurrent, it becomes dependency. So in case of dependency, it will not be a concurrent, and we need to check if one of them are causing the other. So the dominant will be dominant, or the productive reason, as sometimes call it, productive reason will be fully responsible. If dependency is established between delay, employer delay and contractor delay, one party, I answered, this is I think the same question again. Mercedes, please, that would be really helpful if it, as it was helpful.
Mohamed, I think that's in response to us providing a recording and slides. So okay. Yeah, if we can share.
Okay. Thank you.
We're doing the recording tomorrow, just so everyone knows. I'll be sending you, everyone on the list, a recording of Mohamed's talk today. And then you just got one further question there, but the longer we stay here, the more questions will come. AJ sent in another question as well, so I'll let you carry on.
Okay, the final question, but we can make it a final question. What about elements of best endeavors, mitigation, and acceleration, because extend and the validity of extension of time is decided? You need to go first for the definition of mitigation and acceleration. It's a duty for the contractor, as per the SCL, Site of Construction Law. It's a duty of the contractor to mitigate the delay, to minimize the impact or the effect of the delay as much as possible without cost, with a minimal cost, we can say. So there are compression approaches, can overlap some work, change the methodology, do any resourcing or arrangement of the resources to minimize the delay without cost, without paying additional cost. In case of paying cost, it becomes acceleration, not a mitigation, and it's not a duty of the contractor. Acceleration is different scenarios. Can the parties agree on it, or it will be the contractor will be entitled to this extension of time or acceleration cost if it's a constructive. So you need to go the scenarios of the acceleration. So this is about entitlement and acceleration. If the contractor doing pacing delay or get employer concurrent for cost, I said the pacing, it is a critical and challenging. They need to be a notice for the pacing. Once there is a notice, it will be clear. And then the demonstration and the proving the pacing based on the resources. The contractor already has the resources. He could do the work on time and did it deliberately and in purpose, and to slow down the work and send pacing notice to the employer. This clarity can solve the problems of the pacing and avoid any disputes in this regard. Thank you very much. I answered more questions. I said the final and the answer more.
Yeah, thank you, Mohamed. Really good. Really good. I think I just share some comments that are on there now. I know that Kieran, you've really worked hard today. He's been on both sessions, so probably done about 3 hours of CPD on top of his workload. So well done. I think you need to take a little rest now for absorbing all this information. But I think Hashmi's made a really nice point, saying that I am very comfortable to know that the approach and calculations are subjective. So really happy with your presentation, Mohamed. So yeah, I think if the audience appreciates this, I think we might see you again. We'd love to have you back. And Yeah, we're really grateful for you supporting us today, Mohamed. Fantastic presentation. Thank you.
Thank you. Thanks for your efforts. Thank you very much. I appreciate it. Thank you.
Yes, and so yeah, if anybody is in Saudi, get in touch with us. We've having another event tomorrow night, believe it or not, face to face in Riyadh. So I think we've been, I think May has probably upsold that event to you. If you do happen to be in Riyadh tomorrow night, go down and see the guys. CIOB's grouping together again. It's busy season for us, but we'll go quiet when it comes to winter. So hope you're enjoying these webinars and the event. And yeah, once again, thank you, Mohamed. And good luck with your meeting, which you're about to do next. Yeah?
Yes.
It's still on? It's still on?
Yeah. Yes.
Oh, hard luck. But no, thank you again. We'll see you very soon and have a good rest of the week.
Thank you.
Thanks, everyone. Bye.